The statute of frauds requires that contracts conveying an interest in real property be in writing and signed to be enforceable. The statute of frauds applies to purchase and sales contracts, option contracts, lease agreements, and listing agreements for more than 1 year. The statute of limitations designates that written contracts are enforceable for 5 years. Oral contracts are enforceable for 4 years, also known as a parole contract. A valid contract is one that complies with all the provisions of contract law and contains 4 essential elements: contractual capacity of the parties, offer and acceptance, legality, and consideration. Real estate contracts must contain the 4 essential elements, be in writing, and be signed by all parties who are bound by the agreement. Real estate contracts are not required to be witnessed or notarized. Valuable consideration is the money or a promise of something that can be measured in terms of money. Good consideration is a promise that cannot be measured in terms of money. A bilateral contract obligates both parties to perform in accordance with the terms of the contract. A unilateral contract obligates only one party to the agreement. The offeror is the person making the offer. The offeree is the person who receives the offer. A contract is terminated when any of the following occurs: performance, mutual rescission, impossibility of performance, lapse of time, bankruptcy, and breach. The 4 legal remedies for breach of contract are specific performance, liquidated damages, rescission, and compensatory damages. Assignment refers to transfer, an assignor to a new assignee, of rights and duties under a contract. Novation is the substitution of a new party for the original one. Written listing contracts must include the following information: a definite expiration date, street address and legal description of the property, price and terms, fee or commission, and signature of the owner. A copy of the contract must be given to the owner within 24 hours of execution. Listing contracts may not feature an automatic renewal clause. Power of attorney is a written legal document designating some other person as an attorney in fact. An attorney in fact is authorized to perform certain acts for another as authorized in the power of attorney. An open listing is given to one or more brokers. The seller reserves the right to sell the property and to list with other brokers, and the only broker who sells the property is the one that's going to get paid. An exclusive agency listing is given to one broker. The seller reserves the right to sell the property. The listing broker is entitled to a commission unless the property is sold by the owner. An exclusive right of sale listing is given to one broker who is assured of a commission regardless of who sells the property. A net listing is created when the seller agrees to sell the property for a stated acceptable minimum amount. The broker retains as commission all the proceeds of the sale after the cost of the sale are paid, and the seller receives the agreed upon net amount. A buyer brokerage agreement is an employment contract between the broker and the buyer. An option contract is a unilateral contract to keep open for a specified period of time an offer to sell or lease real property. The property owner grants the prospective buyer the exclusive right to buy the property within a specified period of time for a certain price and terms previously agreed upon. The parties to a sell and purchase contract are the vendor and the vendee, seller and buyer. Real estate sales contracts are bilateral contracts. Sellers must disclose material defects to a potential buyer even if selling the property as is. A radon gas disclosure is required before or at time of executing a real estate contract and lease contracts. This disclosure explains what radon gas is and the possible health hazards associated with radon gas. However, it does not require a radon gas inspection. The lead-based paint disclosure must be given to buyers and renters of residential units before 1978. Sellers must disclose the presence of any known lead-based paint, and buyers and renters must be given an EPA pamphlet. At the time of or prior to signing the sales contract, purchasers must receive an informational brochure about energy efficiency that informs them of their right to have an energy efficiency rating performed on the structure. Florida law requires sellers of property subject to a mandatory homeowners association to provide buyers with a disclosure summary regarding the association, existence of restricted covenants, and any assessments that the association imposes. Purchasers must be given a property tax disclosure concerning ad valorem taxes before or at the time of executing a sales contract. The disclosure cautions buyers not to rely on the amount of the seller's property taxes as an indication of future property taxes the purchaser will pay. The seller must disclose to the buyer any pending building code violations. A Community Development District, CDD, is an independent special district created to service the long-term specific needs of its community. Misrepresentation is a misstatement of fact or an omission or concealment of a factual matter.